in a sex offense case where the complainant alleges that the defendant engaged in clear violent rape or sodomy, are the people allowed to bring out prior bad acts showing previous sexual misconduct? To find out, you have to read People versus Vargas, but it's 3 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is part of a limited series I'm doing on cases that are landmark cases in New York Court of Appeals criminal history. This is the case of People versus Vargas. The citation for this case is 88 New York 2nd 856 from 1996, published on May 2nd of 1996. The issue in this case, it's a Molineux type case. The question is, in a sex offense kind of a criminal case, when rape is alleged, are prior bad acts admissible to show intent? To understand and appreciate this case, the background that's helpful to know is that in general, in the United States and in New York, you're only allowed to use, the prosecution is only allowed to prove guilt based upon the charged offense. The prosecution is not allowed to show, for example, the person is a bad person, has done bad things, has a bad criminal history, for the purpose of proving guilt. And in fact, you're not allowed to do that because there runs a risk that the jury could convict the defendant not for being guilty of this offense, but for being guilty of past offenses or past crimes. There's a case from 1901, a landmark case that I've covered in another video called People versus Molineux. And in that case, the Court of Appeals established that there are certain circumstances, limited circumstances, in which prior bad acts or prior convictions could be introduced. In general, we know those exceptions under the term mimic, M-I-M-I-C, which is motive, intent, mistake or absence of mistake, identity, and common plan or scheme. This particular case that we're about to talk about, People versus Vargas, is about the intent exception for mimic. What are the facts in this case? The facts are that in 1992, there was a 33-year-old woman who claims that on February 22nd, 1992, she went into the elevator of her Queens apartment building, and the defendant followed her in the elevator, pinned her in the corner, threatened to kill her, blindfolded her, dragged her to the roof landing where he raped and sodomized her. She then stated, this is her allegation, that after the attack, in an attempt to trap the defendant and deliver him to the police, she exchanged phone numbers with him and arranged for a meeting the following day at his apartment, where she then had consensual sex with the defendant at his apartment. So there's 2 different sexual interactions. The first one, according to the victim, is rape, and the second one is consensual, according to the victim. The defendant then claimed that both the interactions were consensual sex on both occasions. The defendant was charged with rape for the first interaction, and which is the rooftop one. And the defendant then claimed consent, right? In light of his proposed consent defense and the admittedly consensual second encounter, the people then made a Molineux application. They said to the judge, we want to introduce evidence of the defendant's previous bad acts in the form of multiple 1983 burglary convictions where it's alleged he accosted multiple women, he fondled them, he demanded sex from them, he was engaged in sexually deviant behavior, according to the decision. People claimed it was necessary to get into that to show that the defendant's intent on the charge night was criminal, was rape. The trial court ruled that people could call the 4 women to testify about the defendant's previous sexual misconduct. And at that point, because the trial court allowed it, the defendant said, I'm going to abandon my consent defense. The defendant was ultimately convicted of rape, sodomy, sexual abuse, and attempted robbery. He appealed. It goes to the appellate division. They affirm it. It goes to the Court of Appeals. And they reaffirm Molineux. They say, mimic still exists. And yes, intent is one of the exceptions that is allowed under Molineux. But when the acts alleged are easily, when the intent is easily inferred from the acts that are alleged, then you don't need, then Molineux does not allow intent to come in. You don't allow prior bad acts to show intent when the acts themselves are clear as to what the intent is. Here they say here there's a danger the defendant would be convicted of sexual misconduct on the basis that he committed the earlier offenses. But where there are 2 contrasting scenarios, okay, and the defendant claims it was consensual, and the victim claims, or the alleged complainant claims that it was clearly rape, and the allegations make that clear, then if the question is just credibility, then you don't need, then it doesn't allow this prior bad act testimony to show intent. Here, the intent was not the issue because if the jury believed the complainant, then the defendant used force, threatened to rape the victim, and then did so. Under those allegations of the victim, the intent was readily inferable from the facts, and it was improper. It was abuse of discretion by the court to allow that testimony of the previous 4 women that would talk about the defendant's previous sexual misconduct of them. Convictions reversed, new trial is ordered. So when there are circumstances where for example, under sexual offense cases, where the allegations, if believed, are readily show criminal intent, then you're not allowed to get into Molineux evidence to show intent. That's the case of People versus Vargas. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.